All right, I have been asked to stream today's videos on YouTube. Are you Mr. Brown?
No.
Your Honor, we will reset Mr. Brown for tomorrow. He's not going to cooperate today.
Gary, I'll refrain from commenting about him whacking one of our court officers upside the head with a 2x4. Which may have something to do with these charges. Sorry, Mr. Mohammed.
Yeah.
Mr. Mohammed, I think your attorney, Mr. Cronkite, is in my courtroom. He will, the camera will switch to him when he speaks. You are here in 22 FY 758 on a 2-count complaint that is alleged to have occurred on the 15th of January, 2022 at or near 100 Burton Street here in the city of Grand Rapids. Count 1 alleges that you did well in the perpetration or attempted perpetration of child abuse in the 4th degree, murder one Dalen Mohammed. Contrary to Michigan law, that charge is a felony punishable by a maximum penalty of life without the possibility of parole. That charge also includes a requirement that DNA be taken upon request. Count 2 is an allegation of child abuse 1st degree. It's alleged, sir, that on the same date, time, and occasion that you did knowingly or intentionally cause serious physical harm to a child. Contrary to Michigan law, that likewise is a felony punishable by a maximum of life in prison. Sir, do you understand each of the charges, what it is you're charged with, and the maximum penalty?
Yeah.
Looks like I'm supposed to give you a friendly reminder that you are on probation to me with Miss Vanderveen for an operating while intoxicated. You're aware of that?
Yes.
And do you have a pending meeting or appointment with her?
In July.
Okay, we will touch base with her. They just included that, but I will recycle it. Sir, did you have an opportunity to speak with your attorney, Mr. Cronkite?
No.
Did you speak with one of the MIDC attorneys today?
Yes.
Did they explain your rights to you?
Yes.
Ms. Mashad, you just popped on the screen.
Yes, Your Honor, I did meet with Mr. Mohammed and reviewed his rights with him.
And Mr. Mohammed, do you understand your rights as explained to you today?
Yes.
Sir, you have the right to be represented by an attorney, and Mr. Cronkite is in my courtroom, has filed an appearance and discovery demands with the court and hopefully with the prosecutor's office. You have the right to be presumed innocent. We will maintain your not guilty status. You have a probable cause conference scheduled for July 5 at 9 a.m. with me here in courtroom 7C, and if needed, a preliminary examination on July 12 at 1:30. That is with Judge Schaefer in courtroom 8D as in dog. Maddie is also in my courtroom. May I hear it from court services regarding a bond recommendation?
Thank you, Your Honor. The defendant is being charged with a capital offense. Therefore, Article 1, Section 15 applies, and the court may deny pretrial release. As stated before, I also wanted to note he is in fact on probation out of 61st. Thank you.
Thank you. Mr. Cronkite.
Thank you, Your
How are
Honor.
you, sir?
I would indicate that in response to the question the court raised, that I have filed my appearance to the prosecution as well as the court. I have been working with this family since January when young Jalen first presented at the hospital. And I have got to know both my client and his parents and other family members. My client's a long-term resident of Kent County. He currently resides in Wyoming, Michigan. He has 2 surviving children. Those children are under the jurisdiction of the court. Judge Gardner is on the neglect abuse case. My client maintains a relationship with the rest of his family, although, as one might expect with the case that's with Judge Gardner, his parenting time has been restricted. So since that petition has been filed, that's affected that. Nonetheless, he has a long standing history of maintaining relationship with his children. He has no prior CPS involvement. His criminal history involves misdemeanors and no violent criminal history that I'm aware of. I was first retained to represent Mr. Mohammed in an out-of-court capacity to assist with the investigation and have maintained continuous contact with him. I hear from him often daily, at the most weekly. I don't believe that he is a flight risk because I've worked with him consistently and he's understood the gravity of the charges that he was being investigated for and is now being charged with. I would indicate to the court that I do believe my client is indigent and would be seeking some indigent services. But having said that, he has managed to retain my services to assist him and did so as soon as he heard that the criminal charges were going to be forthcoming. We know that because I've stayed in contact with at least one of the assistant prosecutors that's been on the case. And we have been actively gathering up medical records and other kinds of information. Obviously, discovery that's now available is going to make that easier. But I will tell you that we have preliminarily secured expert opinions and think that we have substantial defenses, which I don't think it's appropriate to go into in any length. But our preliminary assessment is nonetheless that there are substantial medical issues in this case, that there's significant medical legal defenses available to Mr. Mohammed. He has consistently maintained his innocence and cooperated with me in everything that I have asked him to do. Based on all of that, I think that a modest bond is appropriate. I do understand the severity of the charges, and I understand that the court has some discretion to just deny bond. I think a modest cash surety bond would be appropriate in this case. I don't believe my client's a flight risk. I think I already said that just because of the substantial contact that he's had with me. So I would ask for a modest bond, something that is at least potentially within reach.
Thank you, Mr. Cronkite. I would note for the record that this tragedy occurred about 6 months ago. So I understand that there has been an entire process, if you will, as far as this investigation prior to these charges being filed. I would note that the charges were in fact signed by our magistrate on the 13th of June. Did Mr. Mohammed surrender himself today?
No, we asked the prosecution to allow us to do that, and we didn't know that the charges had been issued until he was met by detectives yesterday. He went voluntarily, but he was not given the opportunity to surrender himself, although we certainly agreed that we would make those arrangements if given permission or the ability to do that. So.
Okay. No, I completely understand the process and was a criminal defense attorney. Additionally, I did family court work and am familiar with Judge Gardner in these circumstances. One of the problems that bonds pose in this matter, and let me pin your client to the screen so that you can actually see him and not me. One of the problems that these cases pose in the complication between the criminal justice system and the family court system is its standard operating procedure to, for example, enter a no contact order. Obviously, with the tragedy of a deceased child, we don't have a victim to prohibit contact, but then you have Judge Gardner in the family court that I assume that case has been ongoing for the 6 months while these charges were being investigated and eventually filed. And you have an ongoing CPS caseworker and established relationship with one of our local agencies.
I think all of that's true, although I will say I'm not on that case.
You are not on that case.
Right.
Okay. And so do you know any of the details as far as, I know that Judge Gardner can be very demanding. I mean, the family court system is rather rigorous to, are the other children in protective custody?
The other children are in the care of their mother.
Okay.
And
our
my client doesn't have any contact with them by virtue of the orders in that case.
The Judge Gardner order.
Correct.
Okay. What I didn't know and was trying to discern is whether there was an reunification plan or anything for the family in place through the family court, because I don't want a bond decision that I make to interfere what has been a process that began 6 months before this came in front of you and I.
Well, I know limited amount of that, based on that. I've had some contact with my client's court-appointed attorney in that case. And
Do you know who
so,
that is?
no.
Mohammed, who's your family court attorney?
My name is Renee Wagner.
Yes.
Okay, I know Miss Wagner. All right.
All right. So in any event, she would be much,
You know who do the children I don't know how many children we're talking about. Do the children as a group have a guardian ad litem or attorney?
there's a guardian ad litem in that case. And I think if I recall, and I have barely touched the surface there, I think that there was an issue as to the establishment of paternity in that case. So even though my client has a parent-child relationship there, I don't think that he's been found legally to be the father. And so I don't think that there's any contact
Is that just
whatsoever.
one child?
Two.
Okay,
There were three total, and Jalen is deceased.
okay. And do you happen to know when the next family court hearing is?
I have it in mind that it's the 20.
Can
Was
I,
it?
can I add into that?
He may have a better
I'll
idea
let,
than
I'll
I
let
do.
your attorney mention that, because obviously Ms. Mashad went over your rights with you today. You understand, sir, one of those rights is the right to remain silent, but your attorney may pause you at any moment. If there's something you think it would be helpful for me to know, I'm always happy to hear from you.
Go ahead, Abdullah, if you can tell us the schedule.
Yeah, so we were supposed to do a conference for June 21st for my son Hakeem. They dismissed it because I didn't sign his birth certificate. And then we had another one today for June 22nd. It was supposed to be at 2:00, but I couldn't be there. And that was for my daughter, Araya. And they said that was just gonna be a conference and for me and the mother to allow to see if she would want unsupervised or supervised parenting time with my daughter.
Do you know if that was with a referee or with Judge Gardner?
As far as I know, Ms. Wagner told me it was just gonna be between her and the prosecutors.
Okay, so maybe Ms. Wagner is there now today talking with the parties in that case.
So my thinking was that we're going to, that was going to be a pretrial, and they were going to kick that can down the road, seeing what happened in the criminal case. So I don't think the court has jurisdiction. I think the court has authorized the petition and held a couple of pretrials.
Preliminary of pretrials, as opposed to actually having a treatment plan in place in the family court.
I think that's true.
Okay, that's precisely what I was trying to discern, Mr. Cronkite, so I appreciate your insight there. The court, obviously, in making a bond decision, has to weigh the severity of the charges, the danger to the community, which is why I ask if you turned yourself in. I understand this is a family relationship. I appreciate, Mr. Mohammed, that you have cooperated with the parties and had Mr. Cronkite play an integral role in this situation. It is possible for bond to simply be denied, but given your lack of criminal history, it does require a cash bond when someone is on probation or on bond and picks up a pending charge. So certainly that is appropriate. Cash or surety bond is appropriate. With capital cases, in the event bond is not denied, your family ties to the community. I have not heard about employment, I don't believe. Is he employed?
My client's currently unemployed.
Unemployed, okay. And I have not received a probation violation related to the existing drunk driving case. So in the absence of a violation, I am given to assume that things have had been going all right in that case. My inclination is to set a high cash surety bond. In the event that bond is posted, I will require, sir, that you report to court services. I am circling their phone number and would require that you contact them within 24 hours of your release. While you are on probation, you may not use or possess any alcohol, marijuana, or illegal drugs. I will order that you obtain or maintain stable employment, not have any weapons, or engage in assaultive behavior. I am going to make it a condition, Mr. Cronkite, that he comply with any orders of the family court or child protective services or their designated agent, their agencies. A lot of times in the family division, CPS may begin a case, but then it's referred to Bethany or Catholic Charities or Samaritas or an agency to actually execute part of the treatment plan. So I will require that you comply with family court, CPS, and contract agencies. Do you have questions for me, Mr. Mohammed?
No.
I am going to, with 2 life offenses, set a $200,000 cash surety bond subject to those conditions.
Want me to give it to you?
Good luck, sir.
Thank
Mr. Concrete, I don't know. Typically, whoever has the PCC would have the prelim. I think that I'm doing the PCC because Judge Schaefer is off after the holiday. So I think technically it's hers, but either way, that it's strange. I'm happy to give you a copy of the notice since you're sitting here with us. Deputy, the interpreter just walked in. Do you have need for a Spanish interpreter today?
No, we do not, Your Honor.
Thank you, Ms. Rocco. You are free to go. Mr. Cronkite will make a copy of that for you. Do you want a copy of the bond paperwork also, sir?
Yes, please.
Okay, there you go.
Mohammed,
All
you're up.
right.
Seriously, you're up.
Mr. Searcy, how you been?
Yes, ma'am. How you doing, Your Honor?
I think I might have been your lawyer in family court, speaking of. Anyway, let's see. I've got 2 files for you, 22 FY 791, which is maybe you failed to appear or something? Hang
No,
on,
I never
Well,
failed.
looks like that's from February 17th of 2022.
Oh, no, I got shot that day. That's why.
Okay, so February
had-
7th, February 7th.
I think I had got shot on the 16th or the 17th. I don't really remember like that. But I woke up on the 26th from my coma. So it
Okay.
wasn't no failure to appear. I go to every court date.
So, Mr. Searcy, it's my job to read to you what you're charged with so that you know I have 2 files for you. The first one, file on top, 22 FY 791, is alleged to have occurred February 17th of 2022 at 335 Burton Street here in the city of Grand Rapids. That is a 3-count complaint. Count 1 alleges carrying a concealed weapon. It's alleged, Mr. Searcy, that you had a dangerous weapon, specifically a handgun, concealed about your person, contrary to Michigan law. That charge is a felony punishable by up to 5 years incarceration and or a fine of $2,500. That charge also includes mandatory forfeiture of the weapon. Count 2 is an allegation of possession of a firearm by a felon. It's alleged, Mr. Searcy, on that same date, time, and occasion that you possessed a firearm when ineligible to do so because you had been convicted of the offense of carrying a concealed weapon, a specified felony, and the requirements for
Excuse me, ma'am.
regaining.
May I ask?
Mr. Searcy,
No,
just
I'm
listen to the judge.
Oh, I'm sorry, Your Honor. I'm sorry. I'm sorry. I apologize for cutting you off.
But you are. So, Mr. Searcy, you can't see the young lady to my right, but Deanne is a court recorder. She has to take down everything that is said in court. So when you speak at the same time I am, it makes Deanne's
I
job.
apologize.
You're doing it. You're doing it.
My
Right.
bad.
Zip, zip, zip. There you go.
My bad.
Still. So when you speak at the same time anyone else is talking, it makes Deanne's job impossible. So I am happy to hear from you, but I am assuming Ms. Mashad is on the screen here today because she spoke to you about your rights, one of which is the right to remain silent. I haven't even gotten through February's cases and I've got June's cases too. So today is simply an arraignment to tell you what you're charged with, so that you know what you're charged with. You can disagree with it, and God bless America, you are presumed to be innocent until proven guilty beyond a reasonable doubt, okay? But it's my job to identify for you that you're charged with having a concealed weapon, that you have a previous conviction and were allegedly ineligible to possess that weapon, and the next is a charge of possession of cocaine. So I'm just identifying for you what you're charged with. You're not charged with robbing a bank. You're charged with having a concealed weapon and being a convicted felon, thus making you ineligible to possess a weapon. The charge of possession of a firearm by a felon is a felony punishable by up to 5 years incarceration and or a fine of $5,000. That offense also includes mandatory forfeiture of the weapon. That's count 2. Count 3 is possession of less than 25 grams of the controlled substance, cocaine. That is alleged also to have occurred the 17th of February at or near 335 Burton Street here in the city of Grand Rapids. That charge of possession of cocaine is a felony punishable by up to 4 years incarceration and or a fine of $25,000. Do you understand each of those charges and the maximum penalty associated with each?
I can speak now, ma'am.
That was a question to you. Do you
Yeah.
understand each of the charges and the maximum penalty associated with those 3 charges from February?
Yeah, I understand, but I just didn't know where some of them came from. But yeah, I understand, ma'am.
So I wasn't there. I'm not the one charging you with those. That is charged by Detective Bayless of the Grand Rapids Police Department. Okay, you're telling me you were then in a coma, so I don't know whether you did or didn't have cocaine on your person, whatever, but 3 charges out of the 17th of February, possessing a concealed weapon, a handgun, being a convicted felon, and having cocaine. That's it from February.
Yes, ma'am.
Then I've got 22 FY 805, which is also a 3-count complaint that is alleged to have occurred the 21st of June, yesterday, at or near Paris and Ardmore here in the city of Grand Rapids. Count 1 is another allegation of carrying a concealed weapon. It's alleged to Mr. Searcy that you had a dangerous weapon, specifically a pistol, on or about your person or contained within a vehicle that you occupied, that specifically being a Dodge Charger automobile. That charge of carrying a concealed weapon is a felony punishable by up to 5 years incarceration and or a fine of $2,500 and also includes mandatory forfeiture of the weapon. Count 2 is an allegation of possession of a firearm by a felon. As I said, it's alleged yesterday near Paris and Ardmore here in the city of Grand Rapids that you had a firearm in your possession when ineligible to do so, having previously been convicted of the offense of carrying a concealed weapon, and that the requirements for regaining eligibility had not yet been met. That charge is a felony punishable by up to 5 years incarceration and or a fine of $5,000, and again includes mandatory forfeiture of the weapon. Count 3 in yesterday's case is an allegation of felony firearm. It's alleged that you had a firearm in your possession when you committed the charged offense of being a felon in possession of a firearm. That charge, felony firearm, adds a mandatory 2 years in addition on top of any sentence imposed in the other counts. Mr. Searcy, do you understand each of the alleged charges and the maximum penalty associated with each of those from yesterday?
Just say yes, Your Honor.
In each of those cases, did you have the opportunity to speak with Ms. Mashad, the MIDC attorney, for purposes of today's arraignment?
Yeah, I had a conversation with her. I told her that I had a lawyer already, but I don't
And
know.
And who would that be, sir?
Jeffrey Kirkhoff.
Okay. I have an empty courtroom, so I don't have Mr. Kirkhoff here today, and we do not have an appearance from him. If you are hiring Mr. Kirkhoff, he is not,
He's already hired for sure.
okay? I'm explaining to you that he's not here,
Yeah.
okay? Again, God bless America, the Michigan Indigent Defense Commission has created this commission or created indigent defense attorneys, Ms. Michaud and Mr. Jennison with us today on the Zoom, are here to represent you. Did you speak with one of them today?
Yes, ma'am.
Did they explain your rights to you?
Yes, ma'am.
Do you understand your rights?
Yes, ma'am.
If Mr. Kirkhoff has been hired, he will need to file an appearance with our court. He will not know the dates I am about to give you. You have a probable cause conference scheduled for June 30 at 9 a.m. with Judge Ross in courtroom 7A, and if needed, a preliminary examination on July 7th at 1:30, also with Judge Ross. Maddie, may I hear from Court Services regarding a bond recommendation in these matters?
Thank you, Your Honor. Due to the nature of the charges, community safety is a concern. The defendant has also been twice convicted of a felony within the preceding 5 years, causing MCL 765.6A to apply, and is therefore ineligible for a PR bond. It should also be noted that he is currently on probation out of 17th Circuit Court for CCW and receiving and concealing a firearm. Thank you.
I have a scribble here that says probation violation 0 bond. Has a probation violation been lodged, or is he held by the circuit court with no bond?
I know that there is a probation violation pending, unsure of the bond situation.
Okay.
Your Honor, he has no bond at this time on that probation violation.
But Gary, my query is that, does that mean he just needs to see a judge in the next day or two?
Yes, there's no court date scheduled yet, so it should be shortly.
So with that, Ms. Michaud.
Thank you, Your Honor. Attorney Joni Michaud appearing on behalf of Mr. Searcy for the limited purpose of today's arraignment only. As he's indicated to the court, he has hired Mr. Kirkhoff to represent him throughout the rest of the case. Regarding bond, he is a lifelong resident of Kent County. He currently resides with his mother and 1-year-old daughter at 534 Ardmore Street Southeast, Grand Rapids, Michigan, 49507. He is employed with L&D Sparkling Clean. He's worked there for the last 6 months. He is in the process of enrolling in classes to complete his diploma. Your Honor, as he indicated to the court, he was the victim of a shooting. He was in a coma for 9 days, in the hospital for 45, had to relearn how to walk, and has continuing follow-up doctor's appointments, a possible upcoming surgery, as well as physical therapy. Your Honor, he does understand the importance of appearing for all future court hearings, and he is motivated to participate in his own defense, as indicated by his retaining of an attorney. Your Honor, we would ask the court to take all of that into account when setting a reasonable bond in this matter. Thank you.
Thank you. Mr. Searcy, what shift do you work?
We have 2, so we go in. Some days we have 2, and some days we have 1. So it'd be probably from like 5:30 until we're done. But it's supposed to be a whole. But it's a couple of us, so we know the job, the building good, so we might get done early. So it'd be from like 5 to 9, or probably it'd be 5 to 8 if we get done good. If we get done fast, then we might go to another building if we got that building that day.
And how often do you have physical therapy?
I have physical therapy probably like 2 times a month.
Okay. Obviously, since you're charged with being a felon in possession of firearm, it appears to me that you should not be permitted to have any weapons in your possession. So no firearms, no weapons in your possession. You must contact court services within 24 hours of your release. You may not use or possess any alcohol, marijuana, or illegal drugs, not engage in any assaultive behavior, and you must maintain your stable employment. I have no earthly idea what circuit court is going to do with you on a probation violation. I don't know if your probation will be revoked and you get shipped to Jackson and the Department of Corrections. But these bonds are only related to these new cases. You have an existing circuit court case going on, and they're going to do whatever they're going to do in that case. Okay, so that's not about this. So I don't want you getting done with me today thinking, cool, I'll post my bond and get out of jail. You still have circuit court for whatever they're going to do. And so I just wanted you to understand that, okay?
So I have a bond, probation hold.
That's what it sounds like to me, because you're on probation to circuit court. So that's what it sounds like.
What about my tube right here? I'll be having to get that. Then I'm supposed to go see my doctor for this. Can you see on the screen?
You're supposed to go see your doctor.
For this?
Okay.
And
Do you have a PIC line?
no, the pick line, no, that is a G tube.
Okay,
I got a big hole in my stomach. Then I got in my inside, I got a hole in the inside too.
okay.
Yeah.
So with that, I'm going to set a $20,000 cash surety bond in each case, subject to those conditions. Okay,
Yes, ma'am. So,
no weapons, have a job, no substances. And circuit court is going to do whatever on their existing case. Okay,
yes, ma'am.
I will make it a condition to comply with circuit court probation. Do you have questions, sir?
I was just hoping that I got a bond because I know I was gonna come to court and everything and all that. I just got to get my daughter. You feel me?
You got a bond. What I'm telling you is that you still have a circuit court problem.
Okay. Yes, ma'am.
All right?
Yeah.
Good luck.
Edward?
Yes.
No guns.
You're all set.
Mr. Edward, you're here in 22 FY 629 on a 2-count complaint alleged to have occurred the 1st of May, 2022 at or near 1409 Kalamazoo here in the city of Grand Rapids. Count 1 alleges interfering with an electronic communications device. It's alleged that you willfully and maliciously prevented, obstructed, or delayed by any means the sending or conveyance or delivery of an authorized communication by or through telephone or telephone line. That charge is a felony punishable by up to 2 years incarceration and or a fine of $1,000. Count 2 is an allegation of larceny, more than $200 but less than $1,000. That is alleged to have occurred on the same date, time, and occasion. It's alleged that you stole a cell phone belonging to Yanai Dao Ding. The value of the property exceeded $200 but was less than $1,000. That charge is a misdemeanor punishable by up to 1 year incarceration and or a fine of $2,000. Do you understand the charges, what it is you're charged with, and the maximum penalty?
Yes, I do, Your Honor.
Thank you. Sir, did you have an opportunity to speak with Mr. Jennison, the MIDC attorney, for purposes of today's arraignment?
Yes,
Did he explain your rights to you?
yes,
Do you understand your rights?
yes,
You have the right to be represented by an attorney, and the circuit court will appoint an attorney to represent you unless you intend to hire an attorney yourself. We will maintain your not guilty status. You have a probable cause conference scheduled for June 30 at 8:30 in the morning with Judge Ross in courtroom 7A. and if needed, a preliminary examination July 7th at 1:30 in the afternoon, also with Judge Ross. Maddie, may I hear from Court Services regarding a bond recommendation? I don't see where I have a report.
I will get you one. Do you want to look at mine first?
Why don't you tell me, and if I have
Okay.
questions, I'll see what yours says.
The defendant did turn himself in on this warrant. He has a stable release address separate from the victim and a limited criminal history. Therefore, we are recommending a PR bond. We'd like to know he does have an active hold out of Ottawa County for failing to pay child support with a $700 cash bond.
I assume the parties were strangers.
I do not believe so.
Okay. Mr. Jennison.
Your Honor, I met with Mr. Edwards. He does have a stable and residence of 433 Burton Street, Southeast Grand Rapids, Michigan, 49507. He has a phone number of 2002.
Tell me one more time, Mr. Jennison. I had
Okay.
Prairie Parkway.
Okay, I got 433
Oh,
Burton
gotcha.
Street.
Yep. Okay,
Okay,
go ahead.
he has a phone number of 202-926-6904. He has an email address of his first and last name, Joseph Edwards, 90@icloud.com.
You have all that, Maddie?
Yes.
Okay.
Okay,
Yep.
he is currently employed, Your Honor. We would also ask for a personal reconnaissance bond.
Mr. Edward, the catch to a personal recognizance bond, and I'm game to do it, but I don't want to set you up for failure, is that you have a hold out of Ottawa County. So as soon as I give you a PR bond and you say thank you, they're shipping you to Grand Haven. So it sounds like from Maddie with Court Services that that's $700.
If he pays, he doesn't have.
And a child support problem, she is nodding her head and saying, if you pay, then they may not send you there.
Correct.
But the catch is, it doesn't go away and it's not what you're here for with us today. So just want you to understand that as soon as I give you a PR bond and you say thank you, you are in a van to the Lakeshore, okay?
Okay.
And you have a court date with us the 30th of June. So if you stay on the Lakeshore at the Ottawa County Correctional Facility, you need to know that you have this court date and an attorney will be appointed. Is someone at 433 Burton?
Yes, I can call.
Okay. That is where the notice of appointment of attorney or any mail from the court will be sent to Burton. So if you get shipped to the Lakeshore to Grand Haven, they need to keep you informed of what's going on in your case. Looks like on the probable cause affidavit that there's some cousin relationship or something. So I am entering a no contact order with Yayani Dandang. No contact with that individual, not being at their residence or place of work. No weapons or assaultive behavior. No alcohol, marijuana, or illegal drugs. I have circled the phone number for court services and you must contact them within 24 hours of your release, whether here or Ottawa County, okay?
Okay.
So your court date again is on the 30th at 8:30 in the morning, courtroom 7A.
Okay.
I will set a $2,500 personal recognizance bond, subject to those conditions. Do you have questions, Mr. Edward?
Yes, you said if I pay that, whatever child support is, I don't have to go to Grand Haven, right?
You don't have to what, sir?
They don't have to ship me to Grand Haven?
That's what court services is nodding their head about. I can't
Okay.
give you legal advice and have no clue.
Okay, see, I can pay it today.
Okay. My job's to make sure you understand this charge that you have in the city of Grand Rapids. Okay?
Yes,
All right, good luck.
thank you.
Thank you, Your Honor.
You're welcome, Maddie. Take care. Mr. Heacock,
Your Honor.
Sir, you have two misdemeanors that are alleged to have occurred yesterday near Leonard and Tamarack Northwest here in the city of Grand Rapids. Open alcohol within the passenger compartment of motor vehicle and driving while unlicensed. Looks like there's a civil infraction for the refusal of a preliminary breath test, so maybe there was a blood draw that they are waiting on. The preliminary breath test is a civil infraction that has a sticker indicating it is $221. I will set that with the misdemeanor. The driving while unlicensed and open alcohol within a vehicle as the driver or operator of the vehicle are each misdemeanors punishable by a maximum of 90 days in jail and or a fine of $500. Do you understand the charges, what it is you're charged with, and the maximum penalty?
Yes, Your Honor, I understand.
Thank you. Mr. Jennison.
MIDC Attorney Craig Jennison for the limited scope of today's arraignment and bond hearing. I went over with Mr. Hickok his misdemeanor evasive rights. He stated that he understood that. He understood my representation of him today. He wishes to plead not guilty and ask for a court-appointed attorney.
So I don't know if there's a drunk driving coming with this. The preliminary breath test makes me think there may be. So you need to know that you have these two cases that are already out of the gate if they're awaiting blood results on the other case. I've entered not guilty pleas for you. I will release you on your own recognizance on these cases under a condition that you not operate a motor vehicle unless you are properly licensed to do so. So these will be set with the city attorney for what are called pretrial conferences. And I have Valley as an address. Is that accurate?
Yes, Your Honor.
Okay, I've entered not guilty pleas for you. These will be set for pretrials. Anything else, Mr. Jennison?
I would like to add maybe an email address for him, Your Honor.
Yep.
Because I understand the mail has not been going too regular recently. So his email address is S as in Sam, EEJAY 19999. So that's 4 9s at gmail.com.
CJ at 1 and 4 9s at gmail.com.
Correct.
I have circled that for my people. Mr. Heacock, do you have any questions?
I guess I'm just more or less curious about when would be the earliest I could possibly get out of here.
That is a question for the men in brown there, because I don't run the jail.
But I'm as far as your order, I'm not required to, I guess, stay here any longer once I post my bail.
There is no bail. I'm releasing you on your own recognizance.
Oh, thank you so much, Your Honor. I appreciate it.
Don't drive unless you got a valid license. You'll
Yes, sir.
get a notice for a pretrial conference and may have other things coming down the pike. Good luck.
Thank you.
Thank you. Mr. Gordon, how you been?
Not good at all.
Your Honor, before we start on this, I would want to iterate on this one. I got a pre-bond report on him regarding an unarmed robbery, but it's my understanding that this is just on past misdemeanor cases. So
Oh, you're ahead of me, Mr. Jennison, because I just took the rubber band off.
Oh,
I have a very large pile and I don't quite know where to start. Failed to appear for, I have sticky notes.
Mhm.
None of this is new, Mr. Jennison, so I don't think it necessarily, I have 2 failures to pay on a drunk driving and an OM, resist, batter, obstruct from 2020. I've got 3 2021 OM cases that he needs to be arraigned on. August 18th, July 16th, and July 16th would be the new arraignment. So I guess, Mr. Gordon, Let's start with the oldest cases up for arraignment, which are alleged to have occurred the 16th of July, 2021. It's alleged you possessed alcohol within a city park and failed to refuse to identify yourself to law enforcement. As I said, that's alleged to have occurred July 16th, 2021. At or near 315 Lexington here in the city of Grand Rapids. Each of those charges, possessing alcohol in a city park and failing to or refusing to identify yourself, each are misdemeanors punishable by a maximum of 90 days in jail and or a fine of $500. Do you understand those charges and the maximum penalty?
Yeah,
I then have a violation of expulsion orders related to 315 Lexington. In the city of Grand Rapids, it's alleged you had previously been expelled from a city park and were present therein on August 18th of 2021. That is also a misdemeanor punishable by a maximum of 90 days in jail and or a fine of $500. So it's three separate misdemeanors, Mr. Jennison. Mr. Gordon, do you understand the expulsion charge and the maximum penalty?
yes,
Thank you, Mr. Jennison.
MIDC Attorney Craig Jennison for the limited scope of today's arraignment and bond hearing, Your Honor. I went over with him his advice of rights in regards to it was a felony when I was thinking of it, but because there is no felony.
There may be a charge coming. I don't have any scribbles and I don't know what brought him into police contact in the last 24 hours. These are all stinky old cases. So
Yeah, so I
you
did.
keep
review-
mentioning armed robbery. Arguably that could come to the walk-in judge this afternoon and he'll be back on videos tomorrow. I
Okay.
have no idea.
Yeah, but I did go over his advice of rights. He stated he understood those. He wishes to plead not guilty to these matters, Your Honor. They asked for a court-appointed attorney.
Any reason you haven't come to court in the last year, Mr. Gordon, to address these?
excuse me.
Any reason it took a year for you to get arraigned?
I don't know. I don't even know what you're talking about.
I couldn't hear what you said, sir.
I don't know what you're talking about.
These charges are from 2021. We're now in 2022. Any reason it took a year to address these charges? My concern in setting bond is that you appear for court. So when you have an interaction that results in charges, it's concerning that we're now 11 months later, 10 and 11 months respectively.
Okay, so when is my court date? So we can get this all squared away.
You're in court now, sir.
Okay, I'm talking.
Your attorney is indicating you wish to enter a not guilty plea, so that means I need to consider what do we set as a bond. And if it's been a struggle to have you show up for court, that goes into my consideration of what would be an appropriate bond to set. So I'm curious if you have any explanation for not addressing these charges in 10 and 11 months respectively.
I thought I did when I spent all that time in jail. I thought those cases were dismissed when I spent all those days in jail.
I'm not aware of any jail time, so that was my.
Excuse me. I did a bunch of jail time, 40-something days, and I think you gave it to me.
Okay, and do you know when that was?
Yesterday. No, I do not. I just got it started yesterday. My memory bad.
Deputy, any idea when Mr. Gordon's last visit was?
Well, it was July 16th and he got out July 18th of 2021, so.
So the 2 days felt like an eternity, Gary.
Oh, I'm not talking about that. I'm talking about the days prior to that. Before the 16th, how long did I do before I did those days?
He was here January 1st to February 20th.
Those are the days that felt like an eternity.
Yep. So the problem with that is January was before any of this happened in July or August. So you don't get credit for January before you commit a crime, July or August.
Yeah, I didn't know I committed a crime, to be honest with you.
Okay, that's what I'm trying to discern is, did the police give you a ticket and how come nothing happened since then?
I don't know what the police do. The police do all type of things.
I'm well aware of that, sir.
Yeah, so I don't try to keep track of what the police do. I don't listen to the police.
Well, my concern is that you might not want to say that, but my concern is if you were given a citation, why did it take 10 months to have you?
I don't believe I was given a citation. Where is the citation?
Well, it's sitting here in front of me with the date of July 16th.
I never received it.
So
I was just hauled off to
sounds
jail
like you went to jail for it.
for no reason at all. Sound like I was kidnapped.
Okay, Mr. Jennison.
Your Honor, he is currently residing at 449 James Street Southeast, Grand Rapids, Michigan. He lives there with his mother. He has lived there his entire life. He is currently employed through a temp service doing factory work. He does not remember, I mean, he's going through a difficult time right now, Your Honor. As you can see, he was in an altercation recently and has had some injuries sustained. We would ask if he would be given a PR bond at this time to allow him to continue his employment and stay at the residence of his mother.
That poses an interesting problem because I then have two failure to pay cases. 22 OD 1876, which is an operating with a high blood alcohol content case, for which, Mr. Gordon, you owe us $2,065.20. Does not look like a payment has ever been made by you to our court since March of 2018. And then I have 20 OM 1346, which is a resist, batter, obstruct from September of 2020, for which you owe $787 and have never made a payment. So my very limited math skills indicate that you're into us for $2,800. What is your plan for clearing up $2,800?
I mean, I can make a payment plan now that I'm working, but I wasn't working at the time. And
Well,
so-
our court has a work program where we pay you $20 an hour to be applied against your fines and court costs. The problem that you've never made a payment in 2 years indicates to
never knew
me, pardon me?
I never knew that. Never got that information.
Yep, you had me as your judge, so I would have told you. But you have a work program. And with that, you're able to work off your fines and court costs if you don't want to have cash money come out of your pocket. So now that you are working, what do you propose as a payment plan?
I can do like $50 a month or something like that.
Well, do you get paid every week or 2 weeks?
I get paid every week currently.
Okay, so if you get money every week, why would we wait to get paid once a month?
So you want to get paid weekly?
Well, I'd like to get paid faithfully when we've never even returned a pop can or paid a dime on this case.
All right. We can make arrangements with that.
What do you propose, sir?
I mean, weekly. So that'd be $100 a month. Where's all this money gonna come from? Well, can I do $20 a week or something like that?
Let's do $25 per week and we'll have your payment due this Friday, okay?
Yes.
And so that's the 24th.
That's the 24th.
Yep, today is the 22nd. So that gets you on track with these cases since you've never, ever made a payment.
Okay.
So on the other cases, we will release you on your own recognizance. You will have a pretrial conference with the city attorney. If you wish to apply for a court-appointed attorney, you may do so. But it strikes me, we need to just have you show up, okay? So you got payment due, and that takes care of these cases. Mr. Jennison said that there may be other charges coming. I don't know about those, but that addresses the 5 open cases that you have with our court so far. Do you have questions, Mr. Gordon?
Yes, do I got another charge pending?
I just got through telling you that I do not know about that. Mr. Jennison is under the impression there may be charges coming. I don't know. I'm not the one that charges you with any offenses.
Okay, thank you.
Okay, good luck.
Let's try to get on track here.
That'd be appreciated. Good luck.
That's all I have for you, Your Honor. Thank you.
Thanks, Gary. Would you be Mr. Richardson? You were supposed to be here this morning and we have a warrant for you, but let's take care of that. Well, let me.